Good afternoon, members of Parliament, support staff, radio listeners, TV viewers, and those viewing by various forms of media. Welcome to this meeting of the Committee of Public Health, Social Development, Labor, Committee meeting number 2 of today, Monday, December 12, 2022. I would like to give a special welcome to the Honorable Minister of Justice, Ms. Anna Richardson, and the Honorable Minister of Public Health, Social Development, and Labor, Minister Omar Atley, as well as their respective support staff. We've established a quorum of 9 members. Please stand for a moment of silence. Thank you. I've received notifications from the following MPs: notice of absence from MP Emmanuel and notice of lateness from the MP Duncan. Are there any need for brief notifications from members of Parliament at this time? MP Bijlani.
Thank you, Chairman. On behalf of the UP Party, I would like to convey my sincere and heartfelt condolences to the families of George William Frederick Leonard and to the families of the Arundel family and friends and the folks at KPMG Police. Thank you.
Thank you for the notification. Do we have any other notifications? That not being the case, a brief notification regarding the meeting tomorrow to be held at 2 p.m. As you know, there is also an opportunity for an informal briefing from members of the CFT that would have been scheduled for 3 p.m. tomorrow in the conference room, but considering that the Committee of Decolonization and Constitutional Affairs will be meeting at 2, I may be proposing, and I'll be open to feedback on that personally after, to hopefully maybe have the meeting at 1 o'clock instead, so that those that want to join the briefing at 3 in the conference room would have enough time to do so. But I will contact the rest of the committee members in that regard. We go over to, we have as agenda point for this meeting a discussion with the Minister of Justice and the Minister of Public Health, Social Development, and Labor regarding immigration/residency and work permit policies. This is IS 648 2020-2021, dated May 10th, 2021. The request was made on behalf by MP Westcott Williams. We go over to the agenda point. Parliament received a letter from the MP S.A. Westcott Williams on May 10th, 2021. This is again IS 648 of the 2021-2022. I believe that might be a mistake. I believe it's actually the 2020 to 2021 parliamentary year, with the request that a meeting of this committee be convened with the ministers of CVSA and Justice to discuss the above-mentioned points. This document can be found on the P drive. Hence today's meeting. At this time, I would like to allow the requester of the meeting a brief opportunity to elucidate her request, after which we will give the floor to the ministers. MP Westcott Williams.
Thank you, Mr. Chairman, and a good afternoon to you, to our support staff, a good afternoon to my colleagues, a good afternoon to both ministers and their support staff here today, a good afternoon St. Martin, those here in the Tribune, as well as viewing this meeting by the different media. Mr. Chairman, thank you for the opportunity to briefly elucidate my reason for requesting this meeting. And as you correctly pointed out, the request for this meeting is dated May 10th of 2021. So more than a year and a half ago. Of course, the request for the meeting to have both ministers present to discuss the policies which tie into each other very much, immigration and labor, to get some feedback from the ministers concerned. At the time, having learned from the Minister of Justice before that time of the strict adherence to the immigration laws, one, a statement by the Minister of Justice. Subsequently, the Minister of Justice indicated that she was in the process of reviewing, shouldn't use the word grace period or anything of the sort, but a sort of leniency for certain categories of employers/employees on the island. In the meantime, the Ministry of Labor was doing its utmost to ensure that the stipulation/regulation that before issuing work permits, it should be ascertained, foreign work permits, it should be ascertained that there are no locals available to fill the positions. In the meantime, that process, if I can judge from the newspaper, that process has been picking up. So, in other words, Mr. Chairman, albeit that this meeting is more than a year and a half old in terms of convening the meeting, I do believe that a matter of immigration and labor, residency permits, labor permits, etc., the policies or amended policies of the government, that these issues still play today. So, Mr. Chairman, based on that introduction, if I can look at the issue of residency, for example, and I know that the minister has made some changes, and I would like these changes to be put into perspective, because issues like the income, proof of income rather, that has been changed. It has been increased, and I would like to know if there is some data underlying this increase. Why was it done? Based on what, etc. If that can be responded to. I also took note of the fact that the filing for residency permits can be done partially, maybe, electronically. And I would like to know from the minister if the intention is that because of this electronic filing, if issues like intake and compliance can be better streamlined. In other words, where your documents go in rather than having to do it twice. So electronically, what are the benefits that the ministry has in mind and has observed? Mr. Chairman, as I continue, the
idea would be for you to have an elucidation at this point. I would be happy to have you first on the speakers list, let's say, to pose the questions. But the intention was for you to more elucidate your request, which I think you've done, but you're kind of going into the questions
yes,
now.
I was.
So I would propose you've elucidated the request. I will then give the presentation, or allow them to do the presentation, and you will be first in the speakers list to pose your questions.
Oh, I have no problem with that, but it's not as if I ask questions, so I guess the presentation would be a general presentation from the ministries.
I believe based on the agenda point, they have prepared a general presentation.
Okay.
And then after that, I will give you the floor as the first speaker to pose additional questions, and then we go to the other members.
Okay, thank you, Mr. Chairman. Have these presentations been shared with, we have received them? Both ministries have made a presentation, will make a presentation, and these have been shared?
They have been shared with Parliament. They're presented here, and very shortly I would expect that you will have them as well.
Thank you.
So you'll get a presentation first from the Minister of Justice, and then we will also have a presentation from the Minister of Labor, and then I will open the floor, and we make a note that the first speaker will be MP Westcott Williams.
Thank you.
Thank you, MP Westcott Williams. Also, just to add some context to the calling of this meeting, it is a meeting originally, let's say it is a meeting with both ministers, and we are in the committee of VSA. In some parliaments, you have joint committee meetings and so on. In this case, we are in the committee of VSA with both ministers present on a similar topic. However, we have had, either within the Committee of Justice or the Committee of Labor, we have had some discussions, some agenda points related to these topics before. So while this meeting has taken quite some time to be called, we know that both committees have been active with both ministers to discuss a lot of these issues. I think now what we will get, having both ministers together and giving this general presentation, will maybe be a culmination of what we've been discussing over the last couple of years between both committees. So I look forward to this opportunity to hear from the ministers. I will begin with the Minister of Justice, and I do understand you have Ms. Glasgow that will do the presentation, if you can introduce her as well.
Yes. Good afternoon and season's greetings, Mr. Chairman, members of Parliament, colleague minister, support staff, the viewing and listening public, and of course, I always give a special recognition to our senior citizens. Thank you, MP Bijlani, first of all, for your message of condolences to the loss within the Ministry of Justice of Officer Arndell. I also extend my sincere and warm condolences to the family, friends, and colleagues, but also to one of my best friends, Miss Elaine Jeffrey, along with Jackie Jeffrey and Michael Jeffrey, who are his siblings. So thank you very much for extending that condolences. Through you, Mr. Chairman, I would like to ask your attention to the projector screen as we hereby give a short presentation regarding the immigration policy in accordance with today's agenda point, which is registered under IS number 648-20-2021, which is dated May 2021. Through you, Mr. Chairman, with a slight approach or a different approach to our normal presentation structure, which you just mentioned, I would like to ask your indulgence, and I introduce my policy advisor in the cabinet, as well as immigration officer, Ms. Tiffany Glasgow, to give details as it pertains to the laws and policies that govern the residency application process. I am also asking that all tuned in and all who are here with us to bear with it, because the translation of this policy or the policy itself in the Dutch structure is very, or can be very direct, very harsh. But I've asked Tiffany to try to convey it in as soft a tone as possible. And to that end, I'd like to turn the floor over to Ms. Glasgow to proceed with the presentation. Thank you.
Okay, yes, and being that this is a committee meeting, we're happy to hear from technical experts that the ministers would like to have present. So we have Ms. Glasgow that will be doing the rest of the presentation. You have the floor.
Thank you, Minister Richardson. Good afternoon, Mr. Chairman, members of Parliament, and to the viewing and listening public. The Immigration Department is governed by a few legislations, but most importantly, the National Ordinance on Admissions and Expulsions, also known as the LTU, the Admissions Decree, and its main policy, the guidelines of the Minister of Justice with regards to the application of the LTU. St. Martin continues to experience a large influx and outflux of non-nationals who has contributed to the social and economic development of the country. As a result of this social and economic development, the country's population composition is diverse and multicultural in nature. With the entry of the 10-10-10 status, in an autonomous structure, St. Martin became administratively responsible for the admission and expulsions of foreign nationals as well as the regulation thereof. As such, it is necessary to evaluate and adjust the current situation and circumstances, which also means the adjustments of its policies. The immigration policy of the former Netherlands Antilles left much to be desired, which manifested itself in particular in a lack of an adequate mechanism to curb the influx of foreigners, such as a lack of control, supervision, logistics, and manpower. As a result, the restrictive admissions policy was deprived of its essential significance, resulting in an uncontrolled influx of foreign nationals. When assessing the admission of a foreign national, it should be tested against the national interest and not solely against the interests of the individual of the foreign national concerned. The interest of the country lies in the generation of sufficient employment through independent business activities by foreigners, highly skilled migrants, foreigners who bring in foreign exchange, and foreigners who will stimulate the economic development of the country. Besides the national interest of the country, when one is granted admission to be able to reside in St. Martin, there are a few factors that must be taken into account, such as financial means and self-sustainability, which is very important. The legislation and policy requires that for an admission of a foreign national in the context of family reunification or family formation, it must be demonstrated by the applicant that he or she has sufficient financial resources on a permanent basis to provide for his or her maintenance or for that of his or her family member or members. The rationale of this requirement is that on the basis the government has a certainty that the foreign national will not, at least not in the short term, be dependent on the government to sustain his or herself. On April 29, 2021, this norm was raised to 3,000 guilders per month. This applies to the guarantor who is a foreign national. In the guidelines of 2012, this standard was 2,000 guilders. The purpose for this increase was due to the fact that the non-national who is admitted to stay with his or her non-national partners is not allowed to work, and maintaining 2 or more persons on a gross salary of 2,000 guilders is just not possible. It is therefore irresponsible to continue to apply the standard of 2,000 guilders gross income per month. With regards to family formation or family reunification in the guarantor's partner is a Dutch citizen, a standard amount was introduced whereby the Dutch citizen must be making at least the minimum wage. Other factors include family life, health and medical insurance. When receiving his or her temporary residence permit, a foreign national must submit a health insurance policy with a minimum validity of 1 year, which is not recoverable during that year. The latter can be demonstrated by submitting a statement on the part of the SZV that the foreign national is insured with her, or by submitting a local private health insurance policy. The insurance must cover the cost of a general practitioner, medicines, special medical treatment, and nursing in a hospital. Only government-accredited health insurance is accepted. Also, when granting a residence permit, it must be seriously considered that when an individual is granted same, this gives them the opportunity to eventually become a Dutch citizen. The guidelines of the LTU regulates the following categories: admission in St. Martin for persons to whom the LTU does not apply or need van toepassing, admission by operation of fellow citizens and special categories of non-nationals, admissions of non-nationals, family reunification and family formation, residence permits for investors, tourists, admissions of persons with the nationality of the United States, students, interns, pensioners, deportations and expulsions, detention, and legal remedies. As it relates to a first-time application, in accordance with paragraph 3.1.1 of the guidelines, it is the rule that a foreign national, when applying for their residence permit as a first-time applicant, he or she must in principle await the decision abroad. However, circumstances may arise which justifies a deviation from this rule. The applicant is then obliged to provide evidence as to why this rule should be deviated from, and the Minister of Justice then decides on this request. I must note that the Minister has gotten quite a few requests since her tenure and has tried her best to respond to each request. As it relates to the renewals of applications, in practice, a distinction is made with regards to foreign nationals between a first application for a temporary residence permit and an application for a renewal, despite the fact that the LTU does not make a distinction therein. An application for a renewal of a residence permit shall be accepted as an extension if the application has been submitted before the expiry of the period of validity. The application can also be submitted up to 3 months after the end of the validity date. This is known as the tolerance period, also known in Dutch as the gedoogtermijn. If this requirement is met, the holder of the permit may await the application in the country, while renewal can only be refused if one of the grounds for withdrawal under Article 14 of the LTU is present, or if the applicant no longer meets the conditions laid down in his or her permit. The foreign national is also deemed to be legally residing in St. Martin during the processing of his or her application for an extension. If the application for an extension is submitted after this tolerance period of 3 months, it will then be considered as a first-time application, of which the applicant must again await the decision abroad. The assessment of this application takes place on the grounds for refusal under Article 9 of the LTU. In special cases, for example, extraordinary circumstances where the applicant can show justifiable evidence of not renewing their permit on time, this must be submitted to the Minister of Justice, who can then decide on the deviation of the application being awaited abroad. Permanent residency. A foreign national who has resided in St. Martin for a continuous stay of 5 years, meaning no gaps within their permits, and who has not subsequently established his or her main residence outside of the country, can be granted a permanent residence permit once applied for. This permit is valid for an indefinite period and no renewal must be applied for, unless the module of the layout of the permit has changed. However, the requirements attached to the permit shall continue to apply. The permanent residence permit can be subjected to an annual fee to be determined by National Decree Containing General Measures, or LBHAM. This permit can also be withdrawn if the permit holder fails to pay this fee on a date of payment. The revocation of a residence permit. The legislator has granted the power to withdraw residence permits to the Minister of Justice or his or her authorized representatives. This is regulated in Article 14, Paragraph 1 of the LTU. Withdrawal can be made on the basis of a conviction of an offense under Article 24 and 25 of the LTU, or imprisonment of more than 3 months for a crime, good morals or public interest, far-reaching need to revoke the residence permit, violation of permit conditions, for example, they are no longer living with their partner, the guarantor has withdrawn their guarantee, or the employer has terminated their employment. A revocation is a decision and should therefore always be communicated to the non-national in writing with reference to legal remedies. Before proceeding with the withdrawal, the person concerned must be heard or at least duly summoned. The latter implies that the interested party must in any event have been given a clear opportunity to say what he or she thinks of the intended revocation and statements of the reasons. Only if the person to whom the decision is addressed is unreachable, the minister can immediately withdraw this permit. After revocation, the non-national concerned will be given a maximum of 6 weeks after the decision has been sent to leave the country on his own free will. The end of a residence permit. The admission of a temporary residence permit ends pursuant to Article 12 of the LTU due to the following reasons: expiration of the period for which a temporary permit was issued, indefinite departure from St. Martin if it concerns a temporary residence permit, leaving his or her place of residence for the purpose of settling outside of St. Martin, or if it concerns a residence permit, a continuous stay outside of St. Martin for a period of more than 1 year, unless the person concerned has stayed outside of St. Martin for study purposes or for medical treatment, provided that he or she has returned to St. Martin within 1 year after the end of study or medical treatment. Obtaining permission by operation of law or the Van Rechtswege, revocation of their permits or expulsion. Appeals. Under Article 7 of the LAR, the interested party may appeal against a negative decision to the court within 6 weeks. In addition, the LAR offers a possibility of objection under Article 55 within the same period to the same administrative body which took the decision. These are just a few general aspects of the policy. Through you, Mr. Chairman, to the members of Parliament, one can see that the policy on immigration is quite large and very complex. Considering the fact that we are in Parliament today with the Minister of VSA, I would like to just touch briefly on specifics related to employment permits. Whether a non-national is eligible for admission in connection with employment, it must be assessed in light of the following 4 questions. 1. Does a foreign national belong to a category which in principle is eligible for admission? 2. Is there sufficient financial resources, meaning means of income? 3. Is there a danger to public order and national security? And 4. Are the regulations for non-nationals met? The period of validity of admission. Residence for the purpose of employment is valid for the duration of the employment permit. This applies both to the foreign national who performs work and to his or her possible dependent family members. There is a disclaimer to same. not because a person gets a work permit means that they automatically receives a residence permit. Of course, this applies in specific cases as it relates to national security. This brings me to the end of the presentation, and now I'll turn the floor over to Minister Richardson, who has one last slide regarding policy changes.
Thank you for that presentation, Ms. Glasgow. Minister Richardson, you have the floor.
Thank you very much, Tiffany, for delivering that very detailed presentation about the immigration laws and how the application process goes and the policies that govern same as per the request. I just wanted to make mention that there are some amendments that are in the pipeline to the guidelines of applications. In particular, one of the things that I have recognized and I'm not in favor of is the adjustment that was made in April of 2021 subjects persons to some degree being too heavily reliant on others to sign guarantee for them. And this brings an element that, without the ability to express it any different, an abusive situation. To be able to not have persons subjected to that, I do have the legal team taking a look to see if we have a legal basis to grant individuals the opportunity to apply for themselves. Yes? Of course, it is contingent on them being able to show their ability to self-sustain financially and the other elements that apply. Another aspect of it is discussions are being looked at in terms of how the request for your account balance. So if you have an existing company, are we asking companies to have X amount on the account when the application is being done? And are we taking into consideration overhead expenditures that comes along with normal operations of companies versus someone who is now applying as a first-time managing director of a company, indicating that they're establishing this company. That company then, yes, has to be able to show that it has that set beginning amount. So let's say, I believe the figure is somewhere around 36,000 guilders. Should the account have that? Because if you're starting out a business, then you need to have certain expenditures. And part of that expense is, even if you are the sole person of the company, you have to receive a salary every month. So does your company have that available balance to self-sustain your person for 12 months or not? And then, as well as I'm having a review done when it comes to jurisprudence that is established. So if the courts have ruled in certain instances and cases, then it makes no sense for us to continue to submit the same scenarios to the court seeking a different outcome. And that as well is in the pipeline to have the richtlijnen or the policy that's attached to it reevaluated and restructured. So I just wanted to mention that that is in the pipeline and that we have no further part of our presentation. Thanks.
Thank you, Minister. And as mentioned earlier, members of the committee, we have actually two presentations today. We've had the presentation from the Minister of Justice and Ms. Glasgow. I will now give the floor to Minister Otley, and then we'll have a presentation there as well. Minister Otley, you have the floor.
You have to change it now?
Perhaps we may need yes, I think we will take a brief adjournment of 5 minutes to switch the presentations, and then we'll have Minister Otley begin. Meeting adjourned.
Yes, it's so cold. Never
Once again, members of the Committee of VSA and those tuned into this meeting, we've had a presentation from the Minister of Justice and her support staff regarding immigration policies, and we will now have a presentation from the Minister of Labor and his support staff regarding labor policies as well. So without any further ado, Minister, you have the floor.
Thank you, Mr. Chairman. Good afternoon to the members of Parliament, the viewing and listening public, my support staff, and my honorable colleague, Minister of Justice, Anna Richardson. Without further ado, I'll dive right into the presentation. Here we have the key points of the presentation. Also, we dive in a bit about the division. We have labor affairs, 2 sections, permit and labor market, and we also have social services. We operate on a legislative basis. The National Decree, General Measures for Subdivision and further elaboration of the Ministry of Health, Social Development and Labor, Article 19, National Ordinance establishing an employment office, National Ordinance on Foreign Labor, National Decree, General Measures on Foreign Labor, Dismissal Ordinance, National Ordinance Financial Aid, National Decree General Measures on the Financial Aid, National Ordinance Medical Aid, and National Ordinance Legal Aid. So, Labor Affairs Section Permits, Processing of Employment Permits, Business Hiring Non-Nationals, Sections, Labor Market, Business, Labor Registration, Vacancy Registration, Waiver Processing, Labor Disputes, Dismissal Applications, the NES, National Employment Service Center, Employment Registration, Business Engagement. We have the aspect of the social service, which handles financial aid, medical aid, legal aid, social work crisis unit. So the process for permit applications: labor registration, vacancy registration. We have the option, depending on the criteria, to waive the 5-week period, but there's a 5-week advertisement period, and to ensure that employers exert all effort to source local labor market. Business submit the employment permit application with supporting documents required by law. Business receive proof of application. Application is evaluated against the legislation, and a decision is rendered in a decree to the business. Legal time frame to render a decision is 6 weeks. Business has the right to file an objection, or if need be, take it to the appeal court to appeal it at court. So the process: vacancy registration, we connect with the businesses, source suitable candidates, refer suitable candidates, interview, prepare final status letter, prepare management report. The job seeking procedure and process: the employment registration takes place, schedule assessment appointment, prepare post-assessment letter, prepare client profile or client development plan, refer client to a suitable service, prepare management report. Here we have some programs and initiatives that took place from 2013 to 2022, which is current. I'll just list the first one. In 2013, the SEI, Employment Through Training Program, Study and Career Fair at Bel Air Community Center. We have many more throughout 14, 15, 16, and as recent 2022, Kids at Sea, Zero to Hero Maritime Training Course, Royal Caribbean Group Career in Cruise, Second Chance Task Force Panel Discussion, the Employability Enhancement Workshop, which is Q4, Women's Empowerment and Career Development Workshop. The initiatives: Employability Enhancement Workshop, the NEST Training Development Program, the Business Information Sessions, National Job Fair Program, NEST Job Portal, www.nest.sx, Rapid Permit Procedures, Projects of National Interest, construction at the airport and also the medical center, We prioritize permits for medical and educational personnel. Some strategic visions of the ministry is to amend the national ordinance and the national decree regulating foreign employment. We want to reduce vacancy notification from 5 weeks to about a period of 2 weeks. Vacancy registration for permits to be done by section permits. Reduce decision-making time frame from 6 weeks to 4 weeks. We want to add an expedite process and fee, increase the fees, begin to utilize the granting of permits for 3 years, extend duration of permit, evaluate criteria to grant permits for an indefinite period, evaluate implementation of the quota, evaluate implementation of the counterpart, rebrand and re-envision the nest, reboost business engagement. Mr. Chairman, if you allow me, I would like to allow Ms. Joss to continue with the statistical information of the department.
Thank you, Minister, and I will indeed give the floor to Ms. Joss Richardson, if she can, although she needs no introduction really, just to introduce yourself and your function for the public. You have the floor.
Thank you, Mr. Chairman, and thank you, Minister Anna Richardson and Honorable Minister Omar Utley. Indeed, I will go through the statistical information. I would like to point out, however, that the statistical information that I'll be sharing is strictly related to the section labor market and also the section permits. The first part of the information is regarding the section employment permits. Let me, your turn to help me out. Right. So we basically have the employment permit applications, and we've kind of scrolled back to the year 2019. Of course, that is in the post-IRMA era. And then we move all the way forward to 2020, 2021, and Q3 of 2022. And you'll see the stats there. You can see in 2019, we had 1,144 permits that were processed, and then we dipped in 2020 to 615, 2021 to 639, and up until Q3 of this year, we are at 482. And you'll see the stats there in terms of the amount of permits that were granted and the percentage that were denied. The top 10 job functions related to the permits, again, you'll see from 2019 all the way to Q3 of 2022. The first top positions are Anamir Meisjes and erotic dancers for both the year 2019 and 2020. Then in 2021, it switches over to teachers and then to the erotic dancers as well. You will notice in the top 10 positions that both Anamir Meisjes and erotic dancer actually always come back around year after year, it being the top 10. After that, there's cooks, the registered nurse, maid. Maid here is primarily maids in households, so household maids, carpenters, plumbers, roof installers, skincare specialists. You have maid, masons, emergency room doctor, etc. We also have then from 2019 all the way again, keeping the alignment with the stats to Q3 of 2022, the top businesses. No surprise there. Lucky Shot NV, Wonderful World of Entertainment NV, doing business as the Platinum Room. Of course, we know the NV here. The Stichting Algemeen Ziekenhuis, which is the hospital, of course, will also be in the top positions there. The Catholic School Board is also mentioned. Maho Hotel Operations, Windward Island Airways, CIA, Caribbean International Academy, etc. The top, I'm just going to move along, the top 10 nationalities for which, of course, these are the nationalities of the non-national for which the business, who's the applicant applying. Top position goes to the Colombians. Thereafter, of Indian descent, Surinamese, Guyanese, Jamaicans. It's kind of scattered here and there, just depends where. Romania also comes into that, and the Venezuelans as well. Again, this is just general knowledge across the board in terms of the 10 nationalities. I just want to pause a minute just to continually make a differentiation here. The Ministry of VSA deals with the business applicant. So the business is the applicant in the process. Okay, so nationality here is not regarding the business in this instance. This is the laborer that the business wants to bring in, just for a point of clarification. We then go to the age group and gender, so just kind of giving you a bit of an idea of the permits that are going to which age group. As you can see, the largest amount of permits actually go to the age group between 25 and 34. And the second in line would be the age group 35 to 44, and then it's differentiated in colors depending on the year. The lowest amount of permits are actually issued to the persons that are 60 plus in age group. And those positions, by and large, go to highly specialized functions. For example, the staff at AUC, as an example, as well as persons in the medical field, so doctors, etc. I'm now going to go into some statistical data related to the section labor market. These statistics that I'm going to share are not all the statistics of this particular section, so we're not going to go into statistics related to labor dispute or dismissals or the amount of labor registrations. Those stats are kind of put aside, and we're going to focus primarily on the statistics that feed into the process related to the employment permit aspect. And just for clarity, the process there is then the vacancies that are being registered at the National Employment Service Center that resides under the section labor market. So the first slide, which is the comparative analysis A, and I'm constantly going to be coming back, of course, to kind of make sure you're focused on the vacancy discussion. So the business registers a vacancy. Between the year 2019 and 2021, you'll notice in this particular graph that 99.1% of the vacancies that were registered were actually in connection with an EP. EP there is employment permit, 99.1% of the vacancies. And out of that bulk, 88.8% of those permits were granted, tied to those vacancies there. So I'll go to the next slide, which is the comparative analysis B. There you'll see the registered vacancies and the registered job seekers. So again, I just want to create a bit of a clarity for you. So the business has to exert effort to source persons from the local labor market, and that effort is exerted through the registration of the vacancy and the publication of that vacancy in printed media, as well as registering it by us, by the NESC. To align the process there, the NESC naturally has to align it with the registered job seekers. So if you look at this comparative analysis here, you'll notice that the registered job seekers and the registered vacancies are not aligned. So you'll see that there are a huge amount of vacancies that are coming in, and the number of job seekers related to those vacancies or that are qualified and have interest in those vacancies is actually very low. So if you look at, not sure if you could see it clear, the construction area, you'll see the number of the registered vacancies is very high, but the number of job seekers available to fill those positions is actually not as high. I'll go to the other slide, the comparative analysis C. The top 10 registered vacancies are cook, maid, teacher, electrician, steel installer, carpenter, plumber, mason, caretaker, security officer. Let me add this in for general interest. Anamir Meishes and erotic dancers do not need to put in a vacancy registration. So you're not going to see an ad in the newspaper from an adult entertainment club saying, you know, we have a vacancy for a commercial sex worker. You're not going to see that. So top 10 desired job functions from the job seekers. And again, this is just to show you the alignment in terms of what job seekers want and what's out there. The top 10 is admin assistant, cashiers, warehouse assistant, waitress, cleaner, front desk agent. Those are kind of like the jobs that actually people want to do. The comparative analysis D, and this is showing you the vacancies and the job seekers. in terms of the, the education and the requirements. So 55.8% of the job seekers actually have only secondary education, whereas the vacancies that are being registered, 53.2% require specialized education or specialized certificates. You kind of have to keep this in your mind as we go through the presentation, because you'll see where that comes to play. 33.9% are in the age group 16 to 24, and 32% are actually interested in financial and medical assistance. Let me just pause there again, because it's important for you to understand that if you're coming in to apply for financial aid, or even medical aid or legal aid, you have to first go through, as a requirement by law, you have to register at NESC as an active job seeker. So that percentage also includes those persons. Very important to get that. And then the general stats. Now, this aspect concerning 2021 to 2022 kind of incorporates the output or the outcome as well of the famed Pamela policy in terms of what was mentioned in the Lance Courant previously under the previous Minister of VSA with the interview aspect. So this kind of feeds into that scenario. So there were about 543 vacancies registered between 2021 and 2022. 37.6% of those vacancies were handled in accordance with that new procedure. 10%, so now I'm going to the graph, 10% of the persons that were invited to go to an interview actually never went to the interview. They never showed up. There's 21% of those of persons also performed adequately, but were not a complete match to the vacancy that the company registered with the ministry or with the vacancy. 14%, which is a double digit, actually performed very poorly at the interview, and a whopping 55% did not match the job requirements. Just allow me to pause here as well. Of all the legislation that the Honorable Minister mentioned in his part of the presentation, it's very important for you to understand that the National Employment Service Center has no legislation that gives it the power or the authority to actually, for lack of a better word, force a business to actually hire someone. So if a business says, no, that was a nice interview, but we actually not going to hire this person, the government cannot overregulate that and say, yeah, but you got to. So that 55% is not shocking to us. It may be shocking to the honorable members of parliament and maybe the general public, but it's not shocking to us because we know that there's a trend there that, they're not going to hire the persons. 34 candidates were actually referred, 29 interviewed that were actually conducted. Some applicants actually ended up withdrawing their interest altogether from the interview. In the interest of time, I'll jump to the business survey stats. We executed a survey of businesses, and it's very promising in certain aspects. Just to quickly go through, 52.9% of the businesses registered at the Department of Labor Affairs came in to apply for an employment permit. That's a high amount. 74.5% of the businesses recruit via local media. 37.3% businesses find it difficult to find suitable candidates. And 56.9% of the business said they have increased training to address workforce challenges. 58.8% of the businesses are willing to create a partnership with a NESC. And then I'll jump down to the last one, 42.6% indicated more recruitment drives. So more and more persons are interested in the national job fairs, etc. as well. I'll jump to the challenges. Again, this is not an all-inclusive overview of the challenges. This is just a snapshot. Remember when I told you a few slides ago to kind of keep in mind the issue with the vacancy? This is a huge challenge. The employers dictate the requirements for the functions. The majority of the vacancies are connected to first-time or renewal of employment permits. Why do we mention this as a challenge? Again, this is no secret. Everyone should know this because we all see this kind of developing on social media with people commenting. So you'll see a vacancy come out and they would say that, well, you know, we need a cashier, but that cashier must, I'm going to do an extreme example and you'll know exactly what I mean. That cashier must have 30 years of experience and the cashier must have a master's degree in cashing. And furthermore, because of the type of business that we have, that cashier must preferably speak fluent English, but also fluent Mandarin. So, you know, and people are like, oh my God, what's going on here with this? We actually have no legislation to actually address that forcefully in terms of adjusting. The power of that vacancy rests exclusively with the business entity. So they can, this is gonna sound bad, but let me just say it. They can manipulate that vacancy to fit exactly to the non-national that they want to bring in. And then that goes to that percentage that I said, 55% of the persons on the local labor market, they don't find a match. So I'm just trying to line that up. Employment registration, the quality of the job seekers coming in, the job placement aspect, low success rate in actually matching the candidates to the registered vacancies for the reasons I just mentioned. Very important point, even if a permit is denied, it does not mean that a suitable local candidate will end up getting the job, and we have a huge amount of data to show that. We also have lack of insight into the local labor market, and that's being addressed by one of the country packages that is going to do the analysis of the labor market. Authentication of the documents is a challenge, and the validation of the relationship between employer and employee in terms of, is there a legitimate labor agreement going on between these two persons? Last but not least is the Vision One-Stop Shop. Just as a point of clarification, Minister, I'm also doing this slide? Yes. Appreciate it. Okay, so the Vision One-Stop Shop, basically this is a vision under the task force. The task force CVSA, Justice and TIAT was established in April of 2022. It was actually a renewal of that covenant. There was a COM decision on August 16th of 2022 to regulate or to introduce the one-stop shop. There will be a standardized application form which will kind of merge together in one application for the LTU and the TWV. TWV is the employment permit aspect, with a central point of intake, and in phase 2, a complete digital platform for the business community and persons to log in and actually deal with both aspects of the residence and the employment permit. And then, of course, there is the task force project initiative that was rendered by COM to regulate the legal status of tenured laborers on the current market here in St. Martin currently. And that's it for the presentation. Thank you, Mr. Chair.
Thank you, Ms. Dross Richardson, and back to Minister Otley.
Thank you. I would like to go back to the previous slide where it was stated that the employers dictate the requirements for the function. This is very important to note, because I would then go to slide 16. Yeah, I think it's this one, slide 16, where it clearly states, because as Minister of Labor, I received many calls and we would receive many emails from various businesses of persons who may have been denied. But if we look at Q3 2022, thus far, 2.5% have been denied. 96.8 have been granted %, right? And what we realize is that we often complain on the department, but when you look and you ask the business, they would say, why is this person required a master's degree? And then I would go and read the ad that the business put out, and you required a master's degree as a business. So with all due fairness, the department would have to ask based on the requirements that you put out. So I tell businesses that we realize sometimes some businesses are exaggerating the requirements for whatever reason, and we just ask them to try to be truthful in the requirements, because what you ask for will be what the department is asking for in the process. It's simple. Thank you, Mr. Chairman.
Thank you to the ministers, as well as Ms. Glasgow and Ms. Dross Richardson, for your presentations and information that you've provided thus far. As I said earlier, I would give first the floor to the requester of the meeting to pose her questions on the topic. Perhaps maybe some have been addressed on the presentation, maybe not, or maybe more questions might come from the presentation. Members of Parliament, you can indicate here if you also would like to speak after MP Westcott Williams. MP Westcott Williams, you have the floor.
Thank you once again, Mr. Chairman, and my thanks to the ministers and their support staff who have presented or made the presentations regarding the two issues at hand. Mr. Chairman, a few questions that I would have had, just a few, have been addressed in the presentation, so I will continue. And I'll repeat the two first questions that I had just in case they were not noted before. The Minister of Justice indicated in her presentation the issue of the change, the increase in the proof of income, and I would like to know based on what has that increase been instituted. So is it based on cost of living, or, you know, so is there a basis for that increase, or it was just a random number? I also ask regarding the electronic filing, and I want to answer it myself from the presentation, and I can be corrected if that is not so, that with the task force that has been indicated, I think, by the Minister of VSA, if that now would streamline the intake and compliance. And now I see it's not only the two ministries, it is three ministries. And is there already some type of an indication as to this process between the ministries, between the three ministries, in terms of how they would approach this entire matter as a unit, or rather not as a unit, but uniformly? Can the Minister of Justice give us a update with respect to the certificate of good conduct, how things are with that, and just an update in terms of where we stand? Has the policy been changed based on court verdicts, and in particular the issue with respect to spouses not being allowed to work? So has that been changed based on the court verdict? I saw that the Minister of Justice indicated many evaluations to be done, and my general question pertaining thereto is the evaluations are being done or are to be done based on what? So on time passed, on change socioeconomic conditions, and if that's the case, then which? I want to thank Mrs. Dross Richardson for the unemployment numbers, amongst others, for the whole comparative analysis that was given. And in the minister's presentation, the minister referred to the legislation on the National Employment Service Center. However, Mrs. Dross indicated that one of the challenges faced is the fact that this legislation is not hard enough in terms of making certain demands on the employers. And so which legislation are we speaking about when the minister referred to that legislation, so that I can get an idea? And does the ministry have an idea as to what can be changed to that legislation to affect what Mrs. Dross indicated is missing in terms of giving it some teeth to do what the service, what the department would like to do? Mr. Chairman, during a previous meeting, when we were asked, or it was asked, if Parliament can receive the advice that was given that led to the temporary policy to offer persons, employers, the possibility to file for persons for who they had not filed yet. That advice was sent to Parliament confidentially, And given the time past, can we receive that advice now? Why is such an advice confidential? It is somewhere here at Parliament, but that would mean that the members of Parliament who wish to peruse this would have to take time out, go up and sit down at the Secretariat to go look through a document. So why is that document still confidential, if it is? And if it's not, then I would like Parliament to release it and put it into the normal procedure of Parliament. Can the Minister of VSA provide an update on the Royal Caribbean Cruise Employment Program? And I know it has a different name. The last time that we heard from the Minister on that, the Minister was not totally satisfied with the outcome of it, and I would like to know, has that improved? Has that situation improved with Royal Caribbean? I asked both ministers if they are aware of one of the latest presentations by the Central Bank for Curaçao and St. Martin regarding the labor situation on St. Martin. Coincidentally, that presentation was made during the Inter-Expo in the Netherlands just last week, referring to unemployment numbers, youth unemployment, etc., etc. So I just would like to know if the ministers and or their departments are aware of that presentation, which, as is usually the case, is publicly available on this website of the Central Bank of Curaçao and St. Martin. And some conclusions are drawn with respect to labor, migration, etc., etc. And in some of the cases, no comparison could be made with the other countries in the Caribbean because St. Martin does not have or did not provide the data. I ask about spouses being allowed or not to work based on court cases. I ask regarding the policy amendments that are in the pipeline and the reason for that, for those. Can the Minister of Labor indicate, are there only the two projects that were mentioned, the hospital and the airport, are they the only two projects that actually make use of the rapid employment, in any case that they can get employment permits rapidly? So are they the only two projects that are presently utilizing that possibility for the rapid employment processing, or in general, in the general interest? I asked regarding the evaluation. Several evaluations were mentioned, 1, 2, 3, 4, and maybe more. And I asked for the reason for these evaluations. So what is the basis? What are we looking for to get out of the evaluation? Do we have any idea, to the Ministry of Labor, do we have any idea what the average salaries are that are being proposed or put in draft working contracts of foreign nationals? Do we have any idea what the average salaries are of persons for whom a request is being made? Foreign worker for who a request is being made. I assume, I want to believe, and I assume that the department receives copies, proposals of the labor contract. And I also assume that in the labor contracts, the amount to be paid by the employer to the employee is mentioned. So does the department have that information that they can give an average of salaries for foreign workers? According to what exotic dancer policy are the ministries operating now? So what policy is in place? I know they don't have to make a advertisement, but according, what is the larger policy regarding such? I requested already if the ministry can provide the proposed changes to the National Employment Service Center that could give it some more teeth to do what is really expected of it, and that is to ensure that the law that speaks of employment of locals before anything else, that can be executed in the way that the legislation is meant. Reference was made to the country packages, and in addition to the analysis of the labor market, the country package also mentioned the issue of immigration and illegal work, etc. Can both ministries indicate where those projects as part of the country package stand now, and have the ministries received any draft, what do they call them again, plans of approach for these matters? And then there has always been this issue of the oneigenlijk gebruik, so kind of like misuse of the director's license. How have the ministries concerned been able, if they have been, to curb this phenomenon? And what is the status now? Is it still something that the ministries feel that is being used as a loophole in terms of getting around the work permit procedure, or is it no longer an issue? Mr. Chairman, with those questions, I would like to suffice for now. Thank you.
Thank you, MP Westcott Williams. I'd like to take a brief adjournment of 3 minutes, and then we go to the next speaker. Good afternoon once again, members of the Committee of VSA and those viewing this meeting. We've had presentations from both the Ministers of Justice and the Minister of VSA and questions posed then by MP Westcott Williams, the requester of the meeting. We now go over to the next speaker, which is MP Pantaflet.
Thank you, Mr. Chairman. Good afternoon to the Chair, Khifid, of course, both Ministers, Anna Richardson of Justice and Minister Otley of the Economic Affairs, Labour, and also the presenters, Ms. Payandros and also Ms. Glasgow. Right. Mr. Chairman, the presentation started out basically by saying that, of course, the first presentation that adherence to immigration laws are important. And I would say adherence to immigration and labor laws are important. When it comes to the hiring of foreigners, Mr. Chairman, and I follow the details and everything, and data is always important. What I want to see happen, because I look at data and stuff, but I look at also what is happening in reality. And I'll continue to stress that for as long as I can do so until I really see an actual change, which I know will not happen overnight because it is something that's been there for many, many years. And it comes to the issue of again of when, who submits and who employs or who does what. Why do I say this? It is the employer that has to request the employment permit. That's where it starts. The employer has to request it, so not the employee. Now, my complaint and concern has been mentioned more than once as to the issue of who has to pay for the processing of the document. And up to now, that problem cannot be solved apparently because you still find the employee paying to process the document and the employer takes it out of their salary. That's a fact. We must find a way around that. The issue of the, I believe a covenant was signed. Is it a covenant? Because I wasn't sure whether it's protocol. I think it's a covenant. And my question on that matter, Mr. Chairman, is for how long was it signed? What period? In order to determine exactly, because some folks are saying crazy figures. I said, no, I need to get it from the relevant authorities as to definitely how long is it valid for and when was it signed. Because, again, employers are being given an olive branch. They're being given an olive branch. Because interesting, when I saw the presentation, Mr. Chairman, where I believe out of 91% requesting employment permit, about 88% were granted. So if 88% were granted, then I'm wondering why is it that the director of the St. Martin Pension Fund is concerned about the aging population. So which means somebody's not paying something. Somebody's not paying something, because if 88% was approved, then somebody's not paying something. Because the fund depends on persons who are employed to pay into the fund for those who are of retirement age, such as myself. Mr. Chairman, the request to be allowed to remain on the island. Now, I know the Minister of Justice is receiving many requests for persons to remain on the island, but I'm asking the question, who should receive or who should be granting that permission? Because the first thing you do is apply for an employment permit first, and then a residence permit, unless you're a person who is a pensioner or sole proprietor or whatever. But if you're working for a company, then you have to get an employment permit first. And according to me, that should be done via the Labor Office. So is the Labor Office also, or is the Minister also granting permission for a person to remain on the island while the documents is being processed? That's my question, Mr. Chairman, through you. The matter of the failing to pay the fee, I didn't understand it too well, that the person who's requesting the documents will not be handled, I'm kind of paraphrasing, if they don't pay the fee. Now, if the person should be abroad, number one, again, comes back to the employer. It means that the employer is the one who has to pay that fee. That's why I keep saying, Mr. Chairman, some employers really are getting an olive branch. As a matter of fact, I got a call just yesterday. The person said, my employers still decide that they're not going to file for me. And they've been given permission. And that's why my issue is control and seriously fines are on the books. And that's the authority, I believe, when it comes to employment of the Labor Department, that this should become a reality. Island Council member, I was now member of Parliament. I am still not hearing where any complaints from employees that they're being fined left, right, and center. As I said, I repeat it over and over again until I see it. It's a law on the books. It's not one to be created. The issue of requesting renewal and so on, Mr. Chairman, through you, I had a discussion with the Minister of Justice on the issue of the certificate of conduct, because one of the things that is important is that when they submit their renewal, these persons have to have a certificate of conduct. And therefore, it is important that they don't get a gap, because if it's not ready on time, then you cannot blame the individual because they are waiting on that document. So my advice would be, let them submit their renewal or whatever, a transfer, and then make a note that definitely they have requested the certificate of conduct but have not received it as yet. So make a note, because it should not be that because they're waiting, their documents expire, and then they have a gap, and then in future, if they want to apply for Dutch nationality because of the gap, they will not be able to comply for such. The issue of signing for themselves, I'm glad that the Minister of Justice mentioned that. As a matter of fact, this morning, through you, Mr. Chairman, to the Minister of Justice, that I spoke to someone and I said, one of the things that the Minister said plain, definitely if you want to be self-employed, you must have a company, because there's no law saying that you can just come up, whatever you're doing and just apply for yourself. You must have some kind of company in place in order to do so. But in this case, they cannot do a sole proprietor because they are undocumented. So in other words, they got to go through the notary in order to establish their business. And I can agree with that thus far, Mr. Chairman, through you to the Minister. Employment agencies. Mr. Chairman, through you, my question is, how many employment agencies do we have on St. Martin? And how many persons they have working for these agencies? And are they paying the premiums and the taxes and so on? What is their responsibility? What it is that they do? Do they carry the function of an employer, like have a regular employer? Because too often you have persons who are being told, okay, you're not employed anymore, or they're told by the actual person who you're working for that the employment agency is responsible for you, not me. That's why they're hired. So who's really responsible? Who pays the taxes and the premiums? Who does that, Mr. Chairman? So, Chairman, the statistics of the, that was read by Ms. Dross, were interesting. As to the issue again of persons who seek employment, and also the explanation that employers dictate the criteria, which is correct. But again, it comes down to once they have dictated the criteria, now what function is that individual actually executing? See, Mr. Chairman, work immigration back in the 80s, and I have experienced these things. They hire somebody for a manager, but then the person is a normal clerk or whatever in the office. You see, it all comes down, Mr. Chairman, to how much can you control. So, Chairman, one of my colleagues mentioned an issue of whether a married person can work and so on. From my experience at immigration, two non-nationals are not allowed to work, let's say, for instance, let's say one is working and he or she gets married, the partner is not allowed to work, or the wife is not allowed to work. There's an example that not an example, as a matter of fact, an experience that I had recently where, again, this lady called me because what happened is she worked before she got married. She's a non-national. Her husband also, he's admitted, non-national. They both were working. When she got married now, immigration law kicks in where if you don't have a Dutch passport, you're not allowed to work. So what happened was the employer was told, and I said, look, the issue is, if this is the case, you must apply for the wife and let the immigration deny it, or let Labor Office deny it, because the fact is, the permit that a non-national gets, in this case the wife, would be that she's admitted for the time that she's married to XYZ without permission to work. The intended employer can submit a request for her to work. In that case, two things can happen. It can be denied based on whatever reasons, or it can be approved. And if it's approved, then you get a document saying that XYZ is allowed to work for the time that she's married to so-and-so with permission to work. I'm talking what I experienced working immigration back in the day. I don't know if it has changed, but that's what I know. But right now, we have, because she was working before, now that she's married now, the law applies to her. So she's not allowed to work. And basically what has happened to her because of the increase to 2,000 guilders, because both of them income was together, the husband cannot, when he filed for it, had been rejected. So here he is now after 20 years, she has 15 years here, and she's undocumented because she went from unmarried to being married, and now she's not allowed to work while she was working prior to getting married. So my thing is, if she was married, if she was working before she got married, she should also be allowed to work, Mr. Chairman. So these are the realities that I've always said this on this floor, and my colleagues know that. We have the laws, but the laws have to comply with reality, not we change to adopt the laws. The issue of the wage is interesting because I would like to know the statistic of the minimum wage earners on St. Martin. Because as far as I know, minimum wage does not reach anywhere close to 2,000 guilders. So this is going to put a lot of persons who want to get married in a very, very interesting situation. So, Mr. Chairman, I don't deny the reality of what we are facing. And as I said in the beginning, nothing can happen overnight. But these are things that cannot be neglected because we're talking about the lives of persons. And yes, I understand the issue, and we must control the influx of persons. We'll be crazy not to do so. But I've always said we have to be very careful and cautious about the issue of the economy. We want to make sure that these employers, and most of them, definitely adhere to the rules, because I'm sick and tired of hearing the CFT tell us about the issue of tax compliance and so on. We hear that over and over again. So I'm using this platform, Mr. Chairman, to ask the employers who are not doing so to please be responsible and ensure that the economy is moving by paying whatever taxes you have to pay in order for government to do what it has to do. And in closing, Mr. Chairman, the question this is what I wanted to get to finally, the matter of the employers determining the criteria. And I think it was said that we don't have any law in place where it stipulates we can enforce or make them comply with such. My question, Mr. Chairman, through you is, we don't have the law. Is there anywhere in the region that has such a law where a government can tell an employer, you know, this is how it has to be, or this is how it does not have to be? I do not know, because it is said that we don't have a law here. So did they have one in the region or in the kingdom where government can tell an employer, this is how it's supposed to be, and if you don't go according to XYZ, we're going to reject the permit? Thank you, Mr. Chairman.
Thank you, MP Pantaflet. Next, we have MP Bijlani.
Thank you, Chairman. Good afternoon to you. Good afternoon to the Kafir. Good afternoon to the Honorable Minister, support staff, my colleagues, and good afternoon to St. Martin.
MP Bijlani, I think your mic is on, but for some reason, even earlier notification, it sounds a little soft. Maybe align it a little. Yeah. Go ahead.
Good afternoon.
It's a little better.
Is that good? Okay. First of all, kudos to both the ministers of the improvement that I have noticed personally. You know, when you get a personal feeling when you go to the departments, when you're applying for the permits, and I went through that. So kudos to that improvement that you have brought in. Last week, I went to put in the employee permit, labor permit. It was zap, zap, zap. I had no need to call Miss Peggy for that. I had no need to call no one. I personally went and did everything, what was the requirement, and I brought it up, and it was zap. For the Justice Department, I didn't even have to go there. Online, if you have these 11 documents that they want, morning 8 o'clock, I sat. By 8:05, I got a confirmation, your permit is in. Just go and pay this and bring it. No, bring it. Upload that also, is done. Right now, I got a confirmation that your permit is in process. It was fabulous. I did not put up myself as an MP. I went normal as a citizen, took the number, went and registered the same procedure what ABC would do. My face says an MP, but I did not take that opportunity to use it on myself. I was looking at the slide from the Justice, and one line I read is a danger to public order and national security. Who and how you determine that? I would need an answer on that. And the slide by Ms. Peggy Ann on the cook, which is really on top. Are you considered personal cooks and a restaurant needing a cook? Are they all in the same bracket or they are separated? If they're all in the same bracket, of course the number will really go up. I need a cook for my house who can prepare some Indian meal. So everyone, a Chinese is here, an Indian is here, American, this is multinational. So the cook numbers might go up, and I understand that. Now there are a lot of illegals here. We have been proven that we have some immigrants who are taking shelter here, but honest in work. So a couple of good friends of mine, they said, Cookie, we tried to get contractors to build our house or build apartments for our retirement. We couldn't get, but we employed those illegal, I don't want to take the country names, but they employed them and they made their house. I'm thinking, what did the government make in that? Did they get any money out of this? We did not get no money out of this system, but that man made a house, and he was really willing to pay the government anything. And he even told me, I will take the guarantee of those people who are building my houses till that certain time, 1 year, 2 year, and after that, since in the process there we don't have those kind of labor force, they can be used to train those people here. So you have a win-win situation. Might we could consider that, and we can sit and discuss further on that. On the immigration, I have a few questions. Do you feel that there is a huge relation between immigration and crime on the island? When is immigration helpful to our country and when is it harmful? How do immigrants help in country's economy? That'll be all my questions. Thank you.
Thank you, MP Bijlani. And next we have MP Gums. You have the floor.
Thank you, Mr. Chairman, and good afternoon to you, Rifir, my colleagues, those joining us, to the ministers and their support staff present, and thank you to both and all for their presentations. Minister Otley, through you, Mr. Chairman, according to the details shared regarding the open positions, it would seem like there's a bit of a disconnect regarding what jobs are available versus what people are qualified for. And this is, of course, further highlighted on slide 25, I believe. So I just had two questions about this. What is in place with regards to the working relationship between the Ministry of VSA and the Ministry of ECYS, specifically regarding any data about the current or future availability of these specially educated persons, so whether they need master's degrees, PhDs, etc., or certifications. And regarding especially the vocational vacancies, such as plumbers, electricians, carpenters, etc., can you share a bit as to how the NEPA comes into play regarding those areas and how successful has NEPA been in providing candidates for those specific fields? I know they've had success with the nursing program, but for those specific vocations, if any data is available, if it could please be shared. And this would probably be for the Minister of Justice, through you, Mr. Chair. Can you explain a bit regarding penalties for companies that hire persons off the books? And what's the vision for handling this phenomenon as it relates to the one-stop shop that was shared in the presentation? So that would be all for me. Thank you, Mr. Chairman.
Thank you, MP Gums. Next we have MP Duncan.
Thank you, Mr. Chairman. Good afternoon to you. Good afternoon to the ministers and their support staff. Good afternoon to my colleagues and everyone tuned in. Mr. Chairman, I only have one question for both ministers. I consider one of the most vulnerable groups on St. Martin those children, those adults who were born here and do not have any residency or may have had residency and lost that residency. And so just clearly, I would like an overview on each minister's philosophy, each minister's vision or policy for specifically those children who are now adults, who were born and raised on St. Martin, and are having difficulties, of course, gaining residency or employment. Thank you, Mr. Chairman.
Thank you, MP Duncan. Are there any other MPs? Yes? Which one first? We'll go to MP Grisha Heiliger Martin, and then MP De Weaver.
Good afternoon, Mr. Chairman. Good afternoon to everyone. I'll just get right into it, Mr. Chairman. With regards to the amendment that the Minister of Justice stated that she's going to be looking into the amended policies with regards to the 36,000 guilders for the businesses, just for clarification's sake, is it the focus will be only on the businesses or across the board? So the businesses, the type of businesses, or is it going to be the 36,000 guilders across the board for any business? So are you going to look at a specific business and maybe give a cap on the amount that has to be on the account? Or is it going to be a fixed amount for any business across the board when we're requesting for a permit for a business, once the business has that amount on the account? Regarding the permanent residents, I think, and for clarity's sake, I'm not sure if I heard it correctly, the minister stated something along the lines of once the permit is received, that the person who received the permanent residence will have to continue paying. I'm not sure if I heard it correctly. Just to be clear, is that something she's looking to do? Did she mention this? I'm not sure, just for clarity's sake. Also, in the presentation by Ms. Glasgow, she mentioned in the end that don't believe that not because you received a work permit does it mean you can receive a resident permit. My question is, and I get this a lot of businesses apply for work permits and resident permits. I guess they start with the work permit first and then go on to the resident permit. There's always been an incident where a business put in for a work permit for a particular person. The person had to give in behavior, what do you call that again, that form, certificate of conduct. By the time it got to the Justice Department, that permit got expired because the 6 months was up. Now, is the two departments, this question is to both ministers, is both Labor and Minister of Justice considering working together? Have they also considered perhaps merging the LTU under the Labor Department? Is that something that the two ministers are considering? If not, why not? And if yes, how far have you come with that? And what are your thoughts on that process to make it easier? This has to do with hearing from the Minister of Labor stating something along the lines of the rapid permit processing. MP Westcott indicated, is it only going to be under the hospital and the airport? Is it something that you're looking to do for businesses to process it faster for everyone across the board? I'm just reiterating the question and maybe broadening to get an understanding of where the minister is going with the rapid permit processing. Is it only for major projects, or is it something that both the Labor Department and the Justice Department is looking on making the process faster? Are you looking to merge the processes together so it can be easier for businesses to get their work permits in and their resident permit for whatever requests they have in general? So is that something that you're looking to do in the near future? With that, Mr. Chairman, I'll leave it there.
Thank you, MP Heiliger Martin. Next, we have MP De Wever.
Thank you, Mr. Chair. Good afternoon to everyone once again. I was really glad that MP Duncan brought up the issue about young adults, because both of us have been involved in helping young adults that actually were born on the island, on St. Martin, on the French side, grew up here, were never really acknowledged by parents, but grew up here their entire life, was educated on the Dutch side their entire life, and now with both of our assistants is actually able to get their papers sorted. And there's a big issue on the island with persons that are coming into adulthood and not having proper guidance within a household to be able to get their papers. And I can even think of a case of someone that I have befriended that came out of one of the orphanages that didn't have anyone to continue their paperwork again. So even though I know that we're talking here about a task force between TEAT, VSA, and Justice, one of the questions that I have is, where does ECYS get involved in this? Now, I understand the sensitivity of our situation here where you're not allowed to go into schools and see who is undocumented, because we also have a system here set up of compulsory education where it's required for you to be there. And I know that in the past, we have had situations, where if the person can prove their existence on the island and going to school on the Dutch side, then there's a little bit of leniency there. But I'm just gonna double up and second on what MP Duncan said. What are we doing, and how do we have an idea of the amount of people that are coming out of our school system without papers? It's not about disclosing their illegal status. It's about helping these persons sort of transition into adulthood, because what happens with these students when they become adults and they don't have papers, they don't pretty much exist. So they're stateless. They have no support. They have no prospects for jobs. And that is the sort of persons that I have been consistently helping even before I got into office. Because when you're turning 18, 19, 20, 21, you want to do the same thing that your colleagues, your classmates are doing, and want to have the opportunity to go away, but then you realize I can't do anything because I never had my papers regulated. Again, it doesn't mean that it's the problem of government. It becomes the problem of government when you have stateless persons within your society. So just to recap, how are we grabbing those persons that are stateless, that do not have their papers, coming out of school, going into a black market workforce? Thank you very much, Mr. Chair.
Okay, thank you, MP De Wever. I see no other speakers at this time signed in to speak, but ministers, I do also have a couple points I would like to add, and I think I can encapsulate what I would like to say as what MP George mentioned earlier, George Pantaflet, that laws have to comply with reality. As both ministers know, I've been in touch, our faction has been in touch over the last 2 years with various work visits and consultations to examine the two key laws, which is the admissions and expulsion law, the LTU, and the foreign labor law, to see how we can bring this more in line with our reality. What I mean by that is that, as mentioned by Ms. Glasgow, we have transitioned from a Netherlands Antilles system to now where both the labor permit and the residence permit falls with our country. But our laws have not made that transition, because in our current system, we still have where the Ministry of Justice issues a residence permit and the Ministry of Labor issues a work permit. In my research, I found that we are outside of the Dutch Caribbean. We're the only country in the entire Caribbean that has such a system, where it is not, let's say, as we call it, van rechtswege, or by operation of law, that when you get a labor permit, it is already understood that you are, of course, able to come into the country. Initially, in having those discussions with the ministers, we saw, that maybe a fair compromise, rather than, let's say, merging the two ministries or departments altogether, is actually to just adjust the process in such a way where, after being granted a labor permit, that the procedure for then getting your residence permit is a van rechtswege procedure, as is done in other countries, as is in line with what we have in our current reality, where it's one government, not that how it was before, island territory gives a work permit and then the Netherlands Antilles has to approve it, so then you would understand having two completely different process. But I do think, and based on the amendments that we have presented to you for your feedback, that it needs to be done at the highest level of our national ordinances at this point. I think it's very good. The one-stop shop actually shows the need for this, because it's the ministries have identified that we need to somehow merge these processes one way or the other. I think the role of parliamentarians is then maybe to go even deeper on a national ordinance level and identify, well, what are some of the changes that can empower the ministries to better do this on a permanent level. Looking at some of those, and I would like the ministers, if they can comment a little bit on some of those crucial things that that we had identified. For example, for what has not been mentioned as yet, an increase to the fees of residency and labor permits. Has any analysis been done on the ministries, both ministries' side, regarding where we should be, even if it's a sort of indexation based on inflation or whatever, adjustments to be made to that? In our legal analysis of both your legislation, you will also find that in one of them, the fees are not actually explicitly in that law itself. It actually points to the Leesjesverordening. It might be more handy to have that embedded into the actual national ordinance, but nonetheless, some feedback on the fees, because I do believe that there is a warrant if better service can be offered and an improved process can be created. Not only is it warranted to charge more, but then with those additional funds, you have an immediate ability to fund, let's say, for example, a NEPA, so that when that work permit is given and that person pays this fee, somehow it can be allocated to get, within 3 years, someone locally to be able to replace that person. Because a lot of the times we talk about the need for foreign labor, and the statistics that I saw today, where you, for example, have 10% of the applicants not showing up to interviews, or not being, or the business feeling that they are not adequate for the position. If you fund more and more people into your educational programs like the NEPA, you take away that excuse, because now it is clear this person has a certificate from a local institution that specializes in hospitality. Why is it this person is good enough for this institution but not for your hotel? So I think that we should make this increase and maybe have some of those funds go towards our local educational institutions, and would like some feedback on that. Another thing that our faction has brought up is the need for a sort of fast-track service. This was actually from MP Bijlani. One of his proposals was to be able to grant a fast-track service that, for example, would be at a cost of 300% of the regular fee, but this would be, for example, someone in a hotel, their executive chef suddenly quits, and they urgently need now a new executive chef. That's not something that you can go through an 8 to 10 week process to do that. They need an urgent person, and they're willing to pay a very high fee to facilitate that hire. What would the ministers feel about the introduction of such a process as well? Another thing that, let's say, falls sort of under immigration and admission and expulsion, and with the granting of residence permit, is residence by investment. In our examination of the LTU, it doesn't explicitly give a legal basis for a residence by investment program. Our proposal would be to add an Article 3B, so after Article 3A, where it would create a legal basis, a very clear legal basis for a residence by investment program, where those that invest in the country or in social and economic programs that have been established by national decree can then get residence in the country. It would be limited and capped how many per year would be allowed to that, because of course you don't want a huge influx of that. But actually capping it at, let's say, to 50 per year actually even makes it more exclusive and makes the demand for it even higher, and you can demand more investment. So I'd like some feedback from the Minister of Justice regarding a resident by investment program. Another point, which is something that our faction has basically championed from since 2016, and it's been mentioned earlier by MP De Wever, MP Duncan, in terms of the situation of people born in St. Martin and basically being stateless. This goes against various international laws and treaties. As a matter of fact, you've seen the Netherlands have adjusted their admission and expulsion laws. They have made changes to their local policies and so on to prevent statelessness in the country. And while we can't grant a passport to someone, at the very least, our country is able to have this person born in St. Martin have their proper residence, if not permanent, at least temporary residence based on their birth. I can understand some of the fears or challenges, or are people going to have an influx of people coming to St. Martin to become citizens? I think that's something that needs to be researched. In my personal opinion, I think that would be grossly exaggerated. You can go to the French side, for example, with asylum. To do that, that is happening already. What we are targeting is those that are sincerely born here and want to be a part of society, are being educated here, but in our current LTU, they can only get that from 16 years old. So they have to go 16 years of their life with question marks on their head, hiding from immigration, hoping to reach their 16th birthday so that they can then apply for that in accordance with Article 3.1F of the LTU. So our proposal would be to also change this and bring it in line with the Prohibition of Statelessness Act of the European Human Rights Council, so that we can really prevent this sort of situation from happening in our country. Other than that, the final point I would like to bring up is related to the American-Dutch Friendship Treaty. A lot of attention is often placed on this from the perspective of the right of an American to become a resident or to work or to invest in St. Martin. However, the Friendship Treaty also speaks of the free movement of nationals. I will quote Article 3 from the treaty, which states, "Nationals of either party within the territories of the party shall be permitted to travel therein freely and to reside at places of their choice." Two questions I have in this regard is, one, is the policy that where a visitor is only allowed to come 3 times per year to St. Martin, does that apply to Americans? And because in my opinion, looking at the Friendship Treaty, it should not. Are Americans able to come to St. Martin multiple times per year without any sort of limitation? And what is the ministry's view? I know in conversation with the minister, you are looking into how we can better apply this treaty to make movement at our airport more efficient, so that way, you know, the questions that you ask an American tourist would be different that you ask for others based on the treaty. Some people have asked, yeah, but America doesn't offer this reciprocally. And actually, when you see when the treaty was signed, shortly thereafter, that's when the visa waiver program came into existence, and the Netherlands was the first country admitted into the US visa waiver program, together with, I think, Japan and a few others. So the fact that we can do the ESTA or before use the visa waiver program shows that there is some form of reciprocity in the treaty in terms of movement of people. So I would like to know from the minister how we are going to be applying this to make tourism especially flourish a little better with our American tourists, who account for 85% of our tourism arrivals. With that, those are some of the points I wanted to bring up at this time. I do see MP DeWeaver and MP Duncan would like the floor again. So which one first? No. So MP DeWeaver. Okay, MP DeWeaver, you have the floor.
Thank you, Mr. Chair. I forgot to mention my thanks again, because in all the time that I've been struggling or being challenged by getting, the paper sorted for the young adults on the island, there's two persons sitting across me here today, which is Minister Richardson and Ms. Glasgow, that have always been there with the rest of their team to assist with it. So thank you in advance for that. And I'm going to go back to the question that I forgot. One of the civil unrest that's happening in Haiti has also been a big issue in trying to get documents. And anyone who knows the island knows that and I'm going to look at Ms. Dross Richardson here, just for a sign that I'm in the right path. Our two largest migrant groups on the island usually is first people from the Dominican Republic. Second, it would be persons from Haiti. And the big challenge is the fact that now that you're dealing with civil unrest in Haiti, it's been really difficult getting documents or verification of documents from Haiti. And with that knowledge there, with us knowing that fact, I would like to know if there is any special considerations happening for persons from Haitian background as they're going through the application process for their papers. Because of the ones that I have dealt with, where they have said that trying to get copies of birth certificates or even any other document from Haiti, even if it's going via the consulate in Curacao, has proven to be difficult given the civil unrest. Thank you, Mr. Chair.
Thank you for that point. We have MP Westcott Williams. You have the floor.
Yes, thank you, Mr. Chairman. Mr. Chairman, just let me add two short questions so that when the ministers are preparing to answer, they can take them along. With respect to the period within which the Ministry of Justice has decided that responses would be given to requests for residency permit, how up to date is the ministry in keeping with that requirement in terms of time? So is there a backlog at the ministry? And if there is, what does the ministry consider the reasons for such? To the Minister of VSA, Minister, of course, we are faced and will continue to be faced with a situation where persons who have been receiving subsequent and continuous work permits and have been able to, especially during the beginning when it could have been controlled, have been able to show proof of medical insurance. However, depending on the age of these persons, it becomes more and more difficult for them to obtain medical insurance. Today, we see many persons walking around who have worked on this island for a long period of time and are not covered medically. From the perspective of the long-announced universal health coverage that this country wants to introduce, should be introducing, is on the books for the longest of time, is any consideration being given for this type of cases? Thank you, Mr. Chairman.
Thank you, MP Westcott Williams. I'll look one more time to the floor to see if there are any other questions at this time. I did miss one other point that I wanted to add, because in line with these changes that we have proposed in legislation, but also based on the changes on a policy level that you are doing, I always look to, let's say, 3 documents that have illustrated the need for these sort of amendments to be into place. One is our governing program, but also, interestingly, in the National Development Vision, but also the Landspakketten, the country packages. There is a section under immigration about improving the process within justice. I believe also it applies to, I'm going to try and pull it up right here. Yes, in deel E9 van de Landspakketten, just to quickly translate in order to improve the wederopbouw stimuleren, long-term improvements to the process, to be able to improve the general process of applying for work and residence permits. And they even have here on the E9, binnen een maand na indienen van de sollicitatie. So in the country packages, they even recommending a time frame for the entire process. So work and resident process within 1 month. I would like to hear from both ministers regarding the implementation and application of E9. I can imagine something like the one-stop shop that was proposed or discussed by Ms. Dross Richardson would probably help with that process. But just to touch a little bit on that part of the country packages. MPs, with that, I see that there have been several questions. I will adjourn the meeting for 5 minutes to discuss with the ministers the way forward, how much time will be needed, and we'll be right back with that after I have that discussion. Meeting adjourned. Good afternoon once again, members of the Committee of VSA and members of Parliament and those viewing. In consultation with both ministers, of course, we've had several questions posed, and this is our last meeting week for this year. In discussion with them, we would like to have them return in the second meeting week of January. With that, however, before going there, we'll actually give them the floor for any closing remarks before we adjourn this meeting. But again, the proposal will be to the Chair of Parliament to schedule this meeting in the second meeting week of January to continue. But in the meantime, I'll start first with Minister Anna Richardson, followed by Minister Otley.
Thank you very much, Mr. Chairman, and thank you to the members of Parliament for the questions that have been posed. I find that the questions are some very healthy ones, some that allows us to have a discussion that does answer a lot of concerns within our communities. In particular, if I may, through you, Mr. Chairman, I would like to be able to allow my closing remarks to answer a question that was posed by MP Westcott Williams from the standpoint of the response letters. There are two types of letters in particular on this subject matter that are relevant. So one of them is persons who is asking for the ability to remain on the island while their documents are being processed. Those come directly to my cabinet, and I can fairly confirm to you that we are up to date with providing those responses. About a year ago, we were severely backlogged with those, but definitely we have a tracking that I can confirm that those are up to date. Now, on the front page of the paper today, there is an article that speaks to someone who is extremely upset with this minister with regards to not receiving a timely response. Those responses are provided or prepared by the appeals committee and presented to the minister to be able to respond. The person who is responsible for that is Mr. Amador Miller, and he did extend an apology to me as minister today for not providing me with the response that I should have sent in a timely manner. I am not happy about that, and it does require me to take some steps to be able to circumvent these things from happening again, and I will do so. So obviously the backlog within our appeals committee is quite high, and for this reason it is creating a situation where persons are not receiving their answers in a timely manner. So on one end, yes, we are up to date, on another, not. So I will tackle the latter. Thank you for the opportunity.
Thank you, Minister Richardson. And next, Minister Otley, for your closing remarks.
Thank you, Mr. Chairman. There were some very, let's say, specific remarks or questions towards Ms. Strauss. We did agree that we'll come back in January. However, we think it's very important that she address some of the comments, especially when we speak of stateless.
Ms. Joss Richardson, you have the floor.
Yeah, just as a point of clarification, because although I do understand through you, Mr. Chair, the statements made by MP De Weaver, as well as to a certain extent other MPs concerning stateless. By and large, the persons that are impacted here in St. Martin are in fact not stateless, because stateless means that they have absolutely no nationality. So, and that's actually not correct. So it isn't that they're stateless, it's that they have the passport, the Haitian passport, because it is based on the nationality of their mother at the time of birth, but they do not have the papers in order to live and or work here. But that doesn't mean that they're stateless. Stateless means absolutely they don't have nothing, and that's not the case. I just wanted to clarify that because having that this meeting is public and on international fronts, I don't think it's wise for us to say we have stateless people here. So just wanted to provide that clarity. Thank you very much, MP De Weaver.
Thank you, Ms. Dross. And actually, I would like to kind of comment on that further. I also used to think the same, that, oh no, statelessness doesn't exist in St. Martin. Actually, what we found, and I've met with these people, I'm not saying it's 10% of the people living in St. Martin, but it's a significant portion. Because what has happened over the last few years, there are also those that had the Dutch passport, and for whatever reason, some changes were made, and they were also withdrawn, and they have become stateless. In addition to that, you also have those, like we mentioned the situation with Haiti. They had a Haitian passport, let's say in the first 5 years of their life, they reach the age of 6, they can't get it renewed. The minute that expires after 5 years, they have no valid passport. They have now become stateless. So there are situations in St. Martin where people have absolutely none. It is more prevalent indeed based on our research, and of course the minister, when you return, definitely touch on that. If there's any information how many people are here born in St. Martin with no residency at all. So maybe there's some, column A, they have a passport but no residency. How many are column B, no passport, no residency? I will tell you, you would be shocked to find out how many people have neither in St. Martin. It does exist, okay? But thank you for that clarification, Ms. Dross. With that, members of parliament, we will adjourn this meeting. As said, the proposal to the chair will be to have it in the second meeting week of January. With that, we adjourn this meeting.